Hello viewers, welcome to our show. I'm Wamadi from Vincent Solicitors. You know, as a routine, I normally come on air to give our audience regular updates on the changes that goes on in immigration. Recently, I can say last month, the Home Office lost at the Supreme Court in terms of people who are applying to bring their spouse, their children, or their family members to the UK who are unable to meet the minimum threshold of the 18,600. Now, what that has done is that it has forced the Home Office to go back to rewrite the law. Now, last week, or so to say, on the 20th of July, specifically, the Home Office has gone to change the law to put into consideration what the Supreme Court has said in that case. The name of the case is MM Lebanon. Now, what that means is that there is a ray of hope for those whose application have been pending, because according to the Home Office, there are about 5,000 cases which are undecided because so many people are unable to meet this minimum threshold. Now, the implication of this decision is that the Supreme Court took a different view from what the Home Office was saying. Because what it is that the Home Office had set up rules and regulations which people must comply. But the Supreme Court had said that no, if you are able to meet this minimum threshold, apart from how the Home Office has laid down the rule, say extraneous, provided this extraneous evidence or proof are justified and valid, then you ought to be considered to be allowed to bring your spouse, your child, or your children to the UK. Now, the other issue that was raised is that even where you don't meet that minimum threshold, if your case is exceptional and very compelling, or the Home Office decision will be unduly harsh, then your case should be considered. And lastly, the Home Office has an argument which is called the Section 55 argument, the best interest of the children. The Home Office was of the view that because there is a legislation in place, that in itself complies with that duty. The Supreme Court said no, that the Home Office need to consider cases where children are involved, not necessarily because of the legislation. Now, what that means is that there is now a ray of hope for those who are unable to bring their spouse because they are unable to meet the minimum threshold, provided you fall within this new legislation. Now, the question is, how are you going to go about this? Our number is on the screen. We always give regular updates relating to immigration. We are 24 hours on. Our numbers are on the screen. We would welcome that you call. If you have this issue, or you have your brothers or sisters or relatives who are stuck because they are unable to meet this minimum threshold, I would suggest that you ring our number on the screen. Call us, send us queries, even on our website, and we'll be able to deal with that. Now, lastly, there is this issue about children who are stateless. Now, if you're a child, it doesn't necessarily have to be that you are from India. Now, the statelessness rule is that it affects or applies to those children who do not have dual nationality. So if you've been living in the UK as a child for 4 or 5 years, so to say, and it is obvious you are stateless, then you would be able to regularize your stay, provided you're stateless. Now, I'll welcome that if you have issues relating to this, you dial our number on the screen and we'll be able to assist you. Lastly, I would have to talk about the nationality. Now, because of these recent changes, the nationality legislation has also been changed recently on the 27th of July, which means it's going to be much more difficult, even if you have stay now, for you to become British. Now, if you have concerns, issue, query regarding to this, dial our number on the screen. We've got a track record of producing results. We've got a track record of making sure that people comply according to the legislation and you get the results you need. If you're also an employer who is facing civil penalty, I know it's quite daunting. Please ring us and we'll be able to assist you. If you've been given a request for information, do not fill the information and send off and think it's common sense. You would end up with the maximum penalty. You need to seek legal advice. A lot of employers, by the time they come, it is at that point which the matter is supposed to be appealed. And at that point, there's nothing we can do about it. Because what you have to realize that the civil penalty regime is quite strict, and it is a strict liability offense. There is little scope for any defense. The much for most employers we can do is to mitigate. And mitigating is, if we are able to mitigate from the outset, then you will end up paying less civil penalty. So there's no point challenging a civil penalty that is unchallengeable and end up getting the maximum penalty. Imagine what 20,000 or 15,000 per illegal immigrant will do to your business. I would suggest that if you have this issue or concern as an employer, our number is on the screen. Do give us a call and we're willing to assist you as best as we can. Thank you, viewers, for listening. And I look forward to meeting with you or seeing you next on the next update. Thank you.